So welcome everyone on this Monday morning. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. And today we are going to spend some time talking about the E-1 visa. The E-1 visa allows entrepreneurs to come to the United States to engage in international trade between the United States and their home country. So let's go over just a few things before we get started. So many of you may know Scott Legal PC is a full-service immigration law firm. Our main specialty is immigrant and non-immigrant visa solutions for entrepreneurs and investors. However, we do assist individuals pursuing various types of visas, including family-based, employment-based immigrant visas, and a variety of non-immigrant visas for a wide range of circumstances, including the E-1 visa for treaty traders. We will be continuing this webinar series, and we are doing at least 2 webinars a month on different immigration law related topics. So please stay tuned for future webinars that are coming up in the pipeline. At the end of this webinar, we will be sending out a few things for the benefit of all participants. We will first send you a copy of the PowerPoint that will be used in this webinar, and that has all the information that will be covered in this webinar. We will also send you a comprehensive guide, which is an ebook that describes the E-1 visa and the qualifications that you can use as a reference for your benefit. We will also send you a link that you can follow to sign up for the additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will be made available on YouTube, and we do encourage you to subscribe and hit the notification button for our YouTube channel, as we regularly upload a variety of immigration law related videos that can be helpful to you. We will also send you a link that you can follow to set up a consultation should you wish to discuss your particular case in more detail with any of our attorneys. Today, I'll be presenting the first half, and we are also very lucky to have Dustin Saldarriaga, who is a senior associate at Scott Legal with a wealth of E-1 visa experience, who has successfully handled a variety of cases, who will be sharing his expertise regarding the E-1 visa and its requirements. Finally, for any questions you may have, please feel free to add them to the chat box, or you can use the Q&A function, and we will try and get to all questions. So without further delay, let us move into our presentation. All right, so let's start with an overview of the requirements of qualifying for the E-1 visa. As you may already know, the E-1 visa is a non-immigrant visa for a person or company who is a trader that engages in substantial international trade between the United States and their home country. So now let's go through the requirements. One of the most important requirements to think about is that you are a national of an E-1 visa treaty country. And many countries in Europe, Latin America, Africa, Asia, really a wide range of countries do participate in the E-1 visa program. And in order to figure out whether your country is in that list, all you need to do is go to Google and search for list of E-1 treaty countries, and a list will pop up. You'll be able to see the list that is regularly updated and published by the Department of State. You can easily see if your country of nationality is in that list. Now, one thing to note is that the country of birth is not relevant in the E-1 visa treaty country nationality context. So let's say you were born in China or India, for example. However, later you get a citizenship of, maybe Canada, Italy, or Mexico, for example. In that case, if your country of nationality, where you have your passport, is a participant in the E-1 treaty program, you can participate as a treaty trader and qualify for the E-1 visa. So it is the nationality that matters, not the country of birth. And this is by contrast to the immigrant visa context, where there is this other concept called chargeability. But in the E-1 visa context, the country where you have your passport is what matters. And if you are a dual national of different countries and one of your nationalities is a treaty country nationality, you can use that treaty country nationality passport to qualify for the E-1 visa. Now, the other important requirement is that there must be a trade between your home country and the United States. So, how do we define a trade? A trade is defined as an actual exchange of qualifying commodities. Um, and we'll go over this in a little bit more detail in the following slides, but this includes goods and services. Now, the other requirement is that the exchange of these qualifying commodities must be traceable and identifiable. There must be a record that you can show to the government about this trade. Now, important element to note is that the trade must already be in existence at the time you're applying for an E-1 visa. So if you're really founding a new, trade relationship and the trade doesn't exist yet at the time you want to apply, unfortunately, that will not really work because the government will expect that there must already be trade for at least months of period of time before you can qualify for the visa. So definitely important to note that the trade must already be in existence. Now, the other requirement to keep in mind is that the trade must be substantial. And what does substantial mean? We will again go over it a little bit in more detail in the following slides. But it won't work if it's just one company or one element of trade. Even if it is a very high dollar value trade, the government is really looking for a continuous flow of these exchanges taking place of goods or services. Now, keep in mind that the trade that we're looking for is international trade. So the trade must be between the United States and the treaty country. And actually, important rule to keep in mind is the 50% rule, right? So when you look at all of the international trade that is going on from that company, at least 50% of the international trade must be between the treaty country and the United States in order to qualify for the E-1 visa. Now, the applicant for the E-1 visa must be coming to the United States to engage in substantial trade, which means the purpose of your trip must be coming in to actively work on the trade. If your purpose is just to come to the United States to get retired and just live in the United States, unfortunately, that will not align with the purposes of the E-1 visa program. You must continue to actively work on the trade in order to be compliant with the E-1 visa requirements. Now, the final requirement to go over is that you must convince the government that you do have the intent to return to your home country once the trade business is over. So after the visa expires, you will be expected to return to your home country. The E-1 visa is unfortunately not an immigrant visa, so it is not a green card. Now, one thing to note, though, practically, though, is that the standard of non-immigrant intent that the government looks at is actually a bit lower than some of the other visa categories that we look at, such as a B1, B2 visa or an F1 visa, where non-immigrant intent is quite heavily scrutinized. But the E-visa categories actually, the government can be a little bit more lenient on, what kind of expressions of intent that they're looking for. So, for example, you can provide a signed statement that that confirms that you intend to return to your home country after your business is over. And usually, in most cases, that would be enough to satisfy the government. So keep in mind that practically it can be a lower bar than some of these other categories of visas. All right. So now let's talk a little bit more about trade. So what can qualify as trade? So the first thing to note is, goods, right? Traditional goods that are traded, such as, fabrics, jewelry, materials, etc. Definitely goods qualify as trade. But another thing that may not be as obvious to people who are first learning about the E-1 visa is that services can also qualify as trade. So, for example, if it is a company that is providing consulting services to US clients and the services are being provided, from the treaty country, such as consulting tax services, marketing services, or other types of services, that can actually be considered as items of trade for qualification under the E-1 visa requirements. Now, important thing to note is how do you prove this ongoing international trade? As we mentioned in the previous slide, all of this trade must be carefully documented in order for you to, qualify for the visa. So let's talk about some examples. One important thing is you should always check the requirement of the consulate where you'll be applying, because different consulates want to see different types of documents. But generally, for many consulates, they want to see trade spreadsheets, which means, a detailed ledger of the trade, describing the amount of the trade, the identity of the client, the nationality of the client, the item that was traded, and the value of that particular uh, um, invoice of that service or goods. So in those kinds of trade spreadsheets, we would do some work to list out all of these items. And the purpose of providing such a trade spreadsheet, one of the purposes would be to show that at least 50% of the international trade that happened was with the United States, because the 50% requirement is definitely important for eligibility. You want to provide the spreadsheet that lists out all of the trade that happened such that you can clearly prove that that was the case. You would also want to provide copies of, excerpts of invoices, copies of invoices that you sent to your clients to support this spreadsheet with actual documentary evidence of the exchange that happened. If you are importing goods into the United States, you would also have bills of lading. If you receive payments from clients, you would have bank statements for your business that show those line items of, client payments being deposited into the business bank account. Those types of evidences are also very important as documentation, supporting documentation in addition to the trade spreadsheet. DHS customs documents can be relevant if you're importing goods to the United States. And finally, the company's tax returns is another important factor to show revenues that helps to show the scale of the business activity that you're trying to describe. All right. So now let's shift gears a little bit and talk about the substantiality requirement for the qualifying trade. How much trade is enough for somebody to qualify for the E-1 visa? Now, one thing to note is that there's no set amount of trade, a specific dollar amount that is required under the regulations. There is no hard and fast rule in terms of substantiality. So there is a little bit of a matter of interpretation on what substantiality means. But let's look into a little bit more further. So the government essentially wants to see a continuous flow of trade between the United States and home country. And one of the factors for substantiality is how many clients do you have, right? So, for example, if you only have one client in the United States, that would not be sufficient to qualify for the E-1 visa with. But by contrast, if you have dozens of clients, that definitely would provide a better case. The other thing to ask is how many transactions did you have with each of these clients? For example, you wouldn't want to show that you just issued one invoice to each client in the past year. You would want to show continuity. So, for example, numerous invoices issued to each of your clients in the past couple of months or years. That would be the picture that you want to show. So let's say you have 5 US clients, and to one of them you have one invoice that is for $5 million. Even if a single invoice is very large, that would unfortunately not be enough, right? You would still want to show numerous transactions over months or years, because the continuous flow is what the government is looking for the purposes of the E-1 visa. Now, one thing to note is that small businesses can qualify for the E-1 visa. The E-1 visa is not just a visa for large enterprises. The value of the transaction is important, but really the most important factor here is the continuous flow. So the number of transactions is what you want to focus on when you're thinking about who qualifies for the E-1 visa. Now, let's talk about how long does the trade need to last uh, before you can apply for the E-1 visa? Because remember, we talked about how the trade needs to already be in existence before you can apply for the E-1 visa. But for how long? Now, there is no minimum time period that's really set in stone in the regulations, but we generally recommend that the trade should have been ongoing for at least 6 months. And we also generally recommend that the trade should exceed, the volume should exceed at least $250,000 per year with US clients in order to qualify for the E-1 visa and meet the substantiality requirement. Now, another thing I want to go over before moving on to the next slide is that the trade must remain substantial even after you have been granted the E-1 visa. If the trade significantly reduces in volume after you get the E-1 visa, that could cause problems at the renewal stage. So that is one thing to keep in mind when you're preparing your application. All right, so now let's move on to some other considerations um, and go over some questions that we commonly get from clients. Must trade already exist at the time I'm applying for an E-1 visa? We did talk about this. We did touch on this on the previous slides, but the general answer is yes, the trade already has to be existing. Now, one exception where the trade is a little bit on the lower side, let's say you started the company in January, now it's June, July, the trade has only been around $100,000 with all clients. But let's say you have 3 or 4 binding agreements for future work with US clients that's higher value. So maybe that could boost up the total expected trade amount. Maybe you could use those kinds of evidences to strengthen a relatively weaker case. But generally, yes, the trade must already have been existing for at least 6 months. That is our recommendation. Generally, with regards to the volume of the trade, as we discussed in the previous slide, we recommend $250,000 or more of the total volume of the trade that is going on with US-based clients. Now, let's say if you're someone who wants to explore business opportunities in the United States, the trade doesn't exist yet, but you still want to be in the US and develop those new relationships. In that case, the right solution is to enter on a B-1 business visitor visa. And once you are in the United States, you develop those relationships, and let's say you return to your home country and you start producing this trade. After you have that couple months of trade activity in the books, then you would apply for the E-1 visa. But if you're in the exploration stage, meeting clients, making contractual arrangements, the B-1 business visitor visa would be the solution for you for that stage. The second question to go over is how much of the trade must be between the United States and the treaty country. And this point we also made several times in the previous slides, but the rule is at least 50%. At least 50% of the international trade must be between the United States and the treaty country. Now let's look at a hypothetical to see how that manifests in practice. An example, a company in Spain manufactures glass and exports it to other countries and also within Spain. So that's domestic trade and also international trade. Let's say that the breakdown of sales is as follows. Sales within Spain total $100,000. Sales to the United States total $500,000. Sales to China total $500,000. Now, when we're calculating the percentage of trade with the United States, we would disregard the sales within Spain. because that's a domestic sales, we will only count the international trade. So now in this hypothetical, the international trade is with the United States and China. Both are $500,000 in value. In this case, the total international trade is a million, but half of that is with the United States. So according to that calculation, definitely this would work in terms of qualifying for the E-1 visa, because 50% of the trade, international trade, is with the United States, since we do not count the domestic sales within Spain. So in this case, you would be able to qualify. So now I think I will turn the mic over to Dustin, and he will help us understand some of the other considerations regarding the E-1 visa.
Perfect. Thank you very much, GA. So the first thing we'll talk about is when it is ideal to apply for the E-1 at a consulate versus USCIS. So just taking a step back and building on what GA has already shared with us, there are basically two pathways to get an E-1 visa or E-1 status. If you're outside the US, your only option is to go to a consulate and get an E-1 visa. If you're inside the US already, for example, if you are a student or if you are on a B1 visa, like GA mentioned before, you can apply to change your status. So if you're, say, on a B1, you would apply to change your status from B1 to E1 status. But USCIS, changing status is only an option if you're already inside the US. So how do you decide which of these two pathways is best for you? As a starting point, I'll just say that for the vast majority of our clients, we recommend applying at a consulate. And the main reason for that is you can only get a visa at a consulate. What is the benefit of a visa? A visa lets you come into the U.S. multiple times. A visa generally has validity of up to 5 years. So basically, you go to the consulate, you get a visa, and you can enter and exit the U.S. freely for 5 years, or the validity period of your visa. When USCIS approves your change of status application, all that is it is permission to stay in the U.S. in that status. So let's say you're on a B1 and you are approved to change your status to E1 status. That's fine as long as you stay in the US. The moment you leave, you abandon your status. So the benefit of having a visa is huge if you plan to travel. If you were to decide that you have no intention of traveling and that you're okay staying in the US for the duration of your E1 status. It's usually, by the way, status is usually approved for a period of 2 years. If you were to say, I have no need to travel, I just want to stay in the US for 2 years, then changing status might be appropriate. But for the vast majority of our clients, they do want to be able to travel to Canada, to Europe, back home to see family. And so the visa is going to make more sense. And the visa tends to also be valid for longer than 2 years. Let's see. So when looking at the criteria, the other thing to keep in mind is which consulate you'll have to apply at. So within the last couple years, the Department of State has started a policy where you must apply for the visa in the country either that you have citizenship in, you have the passport from, or that you are a resident in. So you cannot, for example, be in the U.S., let's say you have a passport from Australia. You're in the U.S. on a student visa and you want to apply for a visa, but you don't want to go back to Australia. In the past, 3 years ago, you may be able to go to Toronto and apply for a visa at the U.S. Consulate in Toronto. That's not really an option anymore. What the Department of State would say is you have a passport from Australia, you need to go back to Australia to apply for that visa. That's the first thing to know. The second is that not all consulates are created equal. So some consulates are very strict, some consulates are less strict. Some consulates see a lot of e-visa applications from very large companies, and I have in mind Tokyo, Seoul. So when a very small business owner applies for an e-visa at those consulates, it can be more risky. So you just need to be mindful of that in the application. Certain consulates like Honduras or Colombia, Bogota, are experiencing extreme delays and or very low approval rates. So one of the things that we provide, one of the services we provide to our clients is really to look at what the options are. If you can apply at more than one consulate, let's say you have citizenship, you have a passport from one country, but you reside in another, or your spouse has a passport from another country, you may be able to apply at that consulate. Or if you're already in the US, it might be worthwhile to change status, to apply for a change of status within the US. But this is a very strategic decision. We would be happy to help walk you through that. But those are some of the considerations when thinking about whether to apply through USCIS or through a consulate. Perfect. So the E-1 visa, one interesting aspect of the E-1 visa is that it tends to be far less burdensome than an E-2 visa. Frankly, our firm handles more E-2 visas than probably any other visa type. And there's good reason for that. If you want to come to the US to build a business in the US, the E-2 visa is a wonderful option. The E-2 visa does not require trade like the E-1 visa does. However, if your business does engage in trade, then you may qualify for both the E-1 and the E-2 visa. And if that's the case, we would tend to recommend the E-1 visa. And the reasons for that are on this slide, and we'll talk about them here. In contrast to an E-2 visa, an E-1 visa does not require that you invest your personal funds in the business. It also does not require that you hire staff in the US. You don't have to have US employees working at your business. You don't even have to create a US business entity. So you don't necessarily have to create an LLC or a corporation in the US. So the requirements, especially that investment requirement and the hiring requirement, tend to be far lower for an E-1 visa. For the E-1, the really core requirement that Jiyae talked about is trade. So if you have a business entity either in the treaty country or in the US, and goods or services are being traded between those two countries, the treaty country and the US, more than 50% international, as Jiyae talked about, then the E-1 requirements are basically satisfied based on that trade because trade really is the core requirement for an E-1. So it is a wonderful option. If you meet that trade requirement, then we are probably going to recommend an E-1 over an E-2. Why would we recommend an E-2 over an E-1? There are a few circumstances. So an E-2 is a better option if you don't plan to maintain that trade. So as Jiyae said, you do need to maintain the trade. So, and again, that's 50% of your international trade. So let's say that right now 100% of your trade was between the treaty country and the US, but you wanted to expand. You wanted to start selling to Brazil, which is not a treaty country. Then we would say, okay, if you plan to reduce your international trade with the US, between the US and the treaty country, below 50%, we can't rely on the E-1. Let's go to an E-2 so that you have that ability. The other thing to keep in mind is, of course, tariffs. So if your business is very susceptible to changes in tariffs, as we know, the tariff policy in the US has been shifting dramatically. You might want the security of an E-2. Because let's say that a change to tariffs means that your revenue plummets, could cause you to lay off employees, then you might want to say, you know what, I don't want to be so dependent on tariffs. I want to actually build a business in the US, sell domestically within the US, and not have to worry about that international trade piece. So the E-2 could be a better option there. However, again, to repeat what I said before, if your business is based on trade between the US and the treaty country, you plan to maintain that trade, then the E-1 could be a wonderful option for you, could allow you to avoid that personal investment requirement, the hiring requirement, etc. Now, there are a few caveats that I'll just add to the broad strokes I just shared. One is, even though you don't have to employ US workers, it can strengthen the application. Again, it's generally not a requirement, but consular officers love to see applicants whose businesses are employing U.S. workers. So it is always a great thing to be able to walk up to that consular officer and say, I have 3 U.S. employees, I have 10 U.S. employees. Every consular officer is going to be happy to hear that. Um, all right, let's see if there's any additional points that are worth making on this slide. So I should say a little bit more about the that there does not need to be a U.S. entity. What I mean by that is there needs to be trade between the treaty country and the U.S. So if the business is based in, let's say, Australia, and there is no business entity in the U.S., so it's just an Australian business, and that Australian business is producing a good or service in Australia and selling it to the U.S., you don't need a U.S. company. So that's what I mean when I say that there does not need to be a U.S. entity. It is okay if the entity is abroad. Again, that's in contrast to an E-2. An E-2 needs a U.S. entity. Um, and similar with the employment figures, where having employees does help. Having a U.S. entity might help because, again, it when you think about consular officers as they think about the structure of the business, it could be helpful for them to see that, yes, I have a U.S. entity, even if it's just for billing procedures in the U.S. or employment of personnel issues in the U.S. Whatever it is, it could be helpful to have a U.S. entity, but it's certainly not a requirement. The requirement is, again, trade. Excuse me. So Jiyae did a great job of talking through the requirements. So what are common reasons for denials? The top one, again, because trade really is core to an E-1 visa. If the trade amount is either low or infrequent, that can be a basis for a denial. So Jiyae mentioned $250,000 of trade annually. So if you have a business that does $50,000 of trade annually, that could raise the risk. Now, again, as I mentioned before, consulates are all different. So in some consulates, a low trade amount might be okay, whereas in others, a trade amount of 100,000 or 250,000 might still be low. So it's important to talk with an immigration lawyer about which consulate would be accepting of the amount of trade that your business has. The frequency of trade is also important. So let's say you have a single transaction over the course of a year that's $1 million. That actually has a high risk of denial because it's not clearly ongoing and regular trade. You want to have ongoing regular trade. So a lower amount, I mentioned single trade of $1 million, it would be better to have trade of $250,000, but showing that that trade happens all 12 months of the year. That would be better. You want to show not only that you have trade of at least $250,000 annually, but also that it's regular and ongoing trade. A second risk factor is if you have only a few clients. So if to continue with our example, let's say you have a company in Australia that sells to the U.S., but you only have one client in the U.S. That could be a problem. Now, there are some cases when it's not a problem. So, for example, if the single client in the U.S. is a major grocery store chain, that might be perfectly fine. But if your one client is a small buyer, or if it's an entity that's related to the entity abroad, so if it's a business you own in the U.S. and that's the only entity buying your products, that could raise concerns at the consulate. So again, you're probably getting the impression that there's nuance to all of this. So if you have any questions, I would say schedule a consultation. We are always happy to talk through with you the realities, the circumstances of your business, your trade, and to see if it's viable as things are, or if there are certain changes that you might be able to make to strengthen the application. Jiyae mentioned that 50% requirement. That is a threshold requirement. So if your trade between the treaty country and the U.S. drops below 50% of your company's international trade, that immediately compromises the E-1 visa and your status. So you want to make sure that you maintain that 50% trade. And as you're applying, you have to hit that point before you apply. The government is going to want to see your total trade, the business's total trade, what percentage of that is domestic, and then what percentage of that is international. And then of that international amount, they want to see that at least 50% is between the treaty country and the U.S. And relatedly, on this last bullet, trade does need to exist at the time of the visa application. So in your application, as Jiyae mentioned, you want bills of lading, you want customs documentation showing that you're actually moving goods, you want contracts showing that you're selling services, if that's what the business produces, and you want all of that to be included in your application at the time you apply. And then relatedly, when you are renewing, again, most important thing is trade. So you want to be able to show in your renewal application that trade is ongoing. Trade has continued since you were last approved for the visa. So you're going to want those bills of lading, customs records, contracts with clients, statements from the E-1 company showing that you're actually receiving revenue from clients, that you're spending money as the company needs to. Trade needs to continue to be substantial, so regular and ongoing, and ideally more than $250,000 annually. And that you've met that 50% international trade threshold. And finally, each consulate does have unique instructions. So whether it's the initial application or the renewal. So you do want to look at, if you're renewing, you want to make sure that you're following the instructions for the renewal. Usually renewals are more streamlined. So the consulate doesn't need to see all of the documentation that you may have submitted at the initial stage. They might only want to see the trade record. So, but you have to check the consulate's instructions to be sure. And just to take a step back, renewal happens in the usually 6 months or so before your visa expires. So if you are given a 5-year E-1 visa, around the beginning of year 4, halfway through year 4, you would certainly want to start the process of applying to renew your visa, especially since there are delays at consulates. You might want to get started a little earlier. And then when your spot in line comes up for the interview, you would fly to the consulate, go to the interview, and just get a new E-1 visa. The process looks a lot like the approval for the initial visa. Perfect. Jiyae,
All
I'm not sure
right.
if any questions came in.
Yeah, I'm not sure as well. I'm going to, yeah, I
Yeah,
don't think we have had any questions at this point. So maybe give, 15 more seconds to see if anyone has any last minute thoughts.
perfect. And yeah, just to repeat what I said before, we are always happy to talk with you over a consultation and to discuss your specific circumstances, any questions you have. As you can tell, a lot of this is unique to where your passport is from, what consulates you have access to, the realities of your business, the consultations as well as just how we work with clients is very much a back and forth where we can advise you on changes to make to your business at the same time as you are sharing with us the realities of your business.
All
So
right,
for us,
Dustin,
yeah,
we have one question and I'm gonna
perfect.
hand it over to you. So,
Okay, so for a small business, is there a rule of thumb on the number of clients needed? I would say there's not really a rule of thumb. It depends on, like I was saying, the amounts of each transaction, the regularity of the transaction. Just to tell you, just to give an example, I have had clients who have a relatively small business, but they're selling to a large grocery chain in the US. So one client, but that grocery chain is buying a lot of those products every month. That is fine. But if it is a small business where let's say you're selling clothing and it's just online customers, you would want a sufficient number of clients to really show that trade is ongoing. I think it's the regular and ongoing piece that should control the number of clients. Meaning, if you have one client, but there's regular and ongoing trade, like with my grocery store example, one client's probably fine. If you need 20 clients, such as if you're selling t-shirts online, you might need 20 clients a month to be able to show that ongoing and regular trade. Again, hitting that $250,000 annual sales and showing that that's happening every month. You might need dozens of customers. So it really does depend really on that regular and ongoing trade piece.
All right. Well, thank you so much, everyone, for your participation. Thank you, Dustin, for sharing your excellent expertise. And we will, yeah, close here if no one else has any questions. And please stay tuned for any future webinars that are coming up. And if you'd like to discuss your particular case at any point, we're always ready to meet with you in a consultation. So, yes, thank you again for your participation today. Thank you, Dustin.
Thank you, Jiyae. Thank you all.